IAS Officers Association, there's some point in what Dr. Singhvi says, don't politicize it between associations.
I understand Dr. Singhvi's concern.
Yeah.
I understand Dr. Singhvi's concern, but I can't argue beyond that.
Now,
I don't know why should we be afraid of Salve addressing on 10 for 10.
No, that's not the point so much. It's about the modalities of our institution.
Don't want to push on it. Lordships don't want to hear. It's perfectly right.
And
starts first. That's for Lordship's knowledge in the facet. But as the intervention was filed a day before the CB sat, your Lordship made it clear on Thursday that your Lordship would not want to go into this. In any event, Maras, it is unprecedented that when the bench is ending, the Lordship has intervened. I would say with respect, it also reflects politicization of the civil service. No point him putting up 2 associations, I start putting up 2 associations. It will send your Lordship's entire time schedule, of which some discipline must be maintained, into a complete curve. I'm leaving these 5 thoughts with your Lordships. Your Lordship is towards the end, Maras. I will, if my learned sticks to his 15 minutes, that is it. I will barely finish at 4 o'clock. This kind of do not allow this.
thinking was. Mr. Solicitor, what we can do is this, so that Premchand Jain is not left undealt with, not dealt with by you. After you finish, when you're towards the end, you can take 5 minutes and distinguish Premchand or whatever you want to say.
Yes.
And thereafter, all that we'll do is that Mr. Salve, only on Premchand Jain, can give us a note, or you can treat it as your note and give it to us in writing. That's all.
He is the sizer of the proceeding. He doesn't rely on Mr. Salve. He is the master of the. So he can deal with it, and
nobody is master.
You can also give us the note. No problem.
I'm not addressing. I'm not arguing on behalf.
What you can do is that you can give us the note. Even tomorrow or day after with a copy.
Yes, we can both give 1 page note on it.
1 page note. You can give your 1 page note to Dr. Singhvi by tomorrow. You can circulate a 1 page.
I leave it at that. I leave it at that. Only
but we'll require an answer from you on Premchand Jain, how you are approaching it,
Incidentally, he doesn't find a mention in his
report. That, honestly speaking, we as lawyers had a detailed discussion. I don't know why should we be afraid of Salve addressing on 10 for 10.
No, that's not the point so much. It's about the modalities of our institution. Frankly, Mr.
There is a discipline of the court with respect.
Normally, as you know, in my court, any intervener comes, we'll hear you for 2 minutes. It's easier that way.
Yeah, I'm sorry.
Bench, constitution bench to allow some. Never done. IAS Officers Association, there's some point in what Dr. Singhvi says, don't politicize it between associations. Therefore, you can say the same thing. We'll give. You can put a note on the record.
I understand Dr. Singhvi's concern.
Yeah.
I understand Dr. Singhvi's concern, but I can't argue beyond that.
Now, suppose after Mr. Salve, Dr. Singhvi says, well, tomorrow there's some intervener. What do? We'll have what sauce for the goose, sauce for the gander.
Anyway, it's not for me to
isn't it?
Defend.
Sir, we'll come. No, I don't want to push on it. Lordships don't want to hear. It's perfectly right.
And you can give us a small note.
Yes, obliged.
Yes.
So, I would, your Lordship wants me to give a note or even that.
You can give us a small note.
Just give it to 1 day or 2 days.
So long as he doesn't argue, Dr. Singhvi may not have any objection.
Sorry?
So long as Mr. Salve doesn't argue, you won't mind.
So long as Mr. Salve,
we all know, this has nothing to do with
do not blatantly back from Mr. Salve while saying that you are not batting for him and don't set up an association of which you concede.
This is not setting up. I am not to say I am assisting the solicitor and I want to take 15 minutes.
All right. We'll now, Mr. Solicitor,
Let's go that way.
Yes. The third layer.
And I'm skipping something which may not detain your Lordship's attraction much. I was on page 38 and I'm wrapping up, is Das. I'm not reading Das. Das is, subordinate services, where the appointing authority is the Chief Secretary. That's all. I have quoted the relevant rules. The rules are framed by the central government, and these are central rules, and the Chief Secretary is the appointing authority. I don't think anybody would be fighting for control over Das. In fact, this word control over bureaucracy itself is a very derogatory word.
And Das postings are done by whom?
Chief Secretary.
By the Chief Secretary.
By the Chief Secretary. Under the rules, kindly have a look at the rules.
And the rules, the CCS rules.
And
The rules.
Yes, CCS rules. Yes.
And also the.
No, even Danic rules. Even Das.
Then it won't apply.
So Das has rules. Lord, please have a look at para 106.
Oh,
106. Rules, that is Delhi Administrative Subordinate Service rules, are made in exercise of the powers under the proviso to Article 309. Then your lordship would come to, my lord, kindly come to 2B. Appointing authority in relation to grade 1 means the chief secretary, and in relation to grade 2, 3 and 4 means the heads of department concerned for the purpose of these rules, as well as central services, classification, control and appeal. That's all. But they are central services, that's all I am saying.
Right.
Now, your lordship, my lord, the Chief Justice of India, my lord, pose a question. That what happens, my lord, when there are appointments to be made? The Dr. Singhvi said that we wanted to make some appointments and there was no resistance. My lord. Fortunately, he also didn't say, but we can't even make appointments. But we can't help it. That's the statutory regime, the appointment, recruitment, etc. is done by UPSC and my lord, as per the statutory rule governing. Please come to my lord, page 42, the last point, my lord, in this written submission.
Posting and transfers.
Posting. The power of creation of civil post has been delegated by the President to the Honorable Lieutenant Governor with a notification dated so and so. Not
Where are you reading?
I'm sorry.
118.
118, para 4, page 42.
118.
118.
Page 42, para 118.
Yes, posting regulation.
Yes.
The power of creation of civil post has been delegated by the President to the Honorable Lieutenant Governor with a notification dated 13th July 59, not under challenge. All civil posts in the government of National Capital Territory of Delhi are governed by the Central Civil Services rules as per the aforesaid notification. All such posts are services under the Union as per entry 70, list 1. All gazetted posts same are filled by exams conducted by UPSC from time to time, whereas all non-gazetted posts filled by Delhi Subordinates Service Selection Board. LG doesn't make the appointment. As per transaction, this is relevant. As per transaction of business rules of NCT of Delhi, any minister may recommend the creation of new civil posts in pursuance of a policy decision which is placed before the Department of Finance, GNCTD, because it needs financial approval, but finance of the Delhi government elected wing in accordance with the rules, and thereafter before the Council of Ministers of GNCTD. The decision taken by the Council of Ministers is forwarded to the Honorable Lieutenant Governor for his approval. Upon approval by the Lieutenant Governor, which is always granted if the proposal is not in conflict with any legal provision. So that is under 239AA4. The proposal is given effect to and the recruitment process is carried on as per the process prescribed in the cabinet note, or else the same is forwarded to the Delhi Subordinate Service Selection Board conducting the recruitment exam in accordance with the rules framed by the framework. That's all. Minister originates the proposal. It goes to Finance Department of Delhi. Finance Department approves it, goes to Cabinet, and the LG forwards it for the appointment unless it is contrary to some law. That's how this is created. Now the position is this. Before I answer the question of Jammu and Kashmir. Now the position is this. Your lordships are requested to examine whether Delhi has the power under entry 41 rule, under entry 41 list 2, without they showing how they fall within. I have shown, my lord, 3 things. Insofar as it is applicable to Delhi, that is to union territories, and therefore your lordships will examine whether any union territory can do this. That will be the test. Union territories, my lord, kindly recall.
Yes, yes.
I have also pointed out to your lordship statutory rules or rules framed by the President under Article 309 proviso, which are not under challenge, conferring something completely different than what they are praying for. They are not under challenge. I am pointing out statutory notifications of the President, which are not under challenge, except 2015 notification. Lord,
Yes.
which is a notification traceable to Article 239, read with Section 41 of GNCTDA. So, if your lordships were to hold that the entry falls with union territories, not necessarily, it would temper with 239 AA 3A, which says union territories, then even Lakshadweep can have their own service. To your lordships, ultimately be setting aside the statutory rules without there being any challenge.
Yes.
And most importantly, my lords, a very harmonious structure which is in existence since beginning of the union territories will be disturbed because of some hypothetical problems being, my lord, highlighted.
Right.
Now, my lord, coming to the Jammu and Kashmir, my lord, and that's, my lord, the last submission. My lord, please take, my lord, the act. My lord, Jammu and Kashmir, my lord, it's volume 1. My lord, it's volume 1, page 1478, PDF page 1478. I'm sorry, P1482.
Volume 1 means convenience compilation. Convenience compilation.
Convenience compilation.
1478.
Lord, I would make, my lord, my submission of Article 4 read with Article 246 good. I have examined that, my lord, in detail. Why, my lord, Jammu Kashmir?
1478.
1482.
1511, my lord, PDF page 1511
No, PDF
is, my lord, the relevant provision, which
1511 is the relevant portion.
Section 93 of State Reorganization Act. My lord, please bear in mind, this is the State Reorganization Act.
Which section you want us to see?
Hmm?
90. Which section?
93, my lord, 93, which my lords would find page 1511, PDF page 1511. Your lordship.
1500 is the second schedule.
Pardon me?
1500 is the second schedule.
No, my lord. PDF page 1511, my lord. Otherwise, 1507. If your lordships are looking at the right side pagination, 1507, section 93.
Yes.
The Public Service Commission for existing state of Jammu and Kashmir shall, on and from the appointed day, be the Public Service Commission for the Union Territory of Jammu and Kashmir. There was, my lord, this is a sui generis my lord, case,
Yeah.
where there was already an existence of Public Service Commission. It became UT. It is continued under Section 4, read with 246.
Yes.
But kindly, my lord, have a look at Section 4 once again. I'm sorry, Article 4 once again. For Lord, I think I'll be able to make this submission. First is, my lord, 3. Kindly see Article 3. Formation of new states, and your lordships would recall, Lord, state here may include union territory. Please see. Formation of new states and alteration of areas, boundaries, or names of existing states. Parliament may, by law, form a new state by separation of territory from any state, or by uniting 2 or more states or parts of the states, or by uniting
So according to it's a supplemental, incidental and consequential provision under section
provisions which would not be treated to be an amendment of the Constitution. My lord, a Constitution bench had an occasion.
Okay. We got your point. We got your point.
I'm sorry, my lord, one more thing. This very provision came up for consideration before a Constitution bench of your lordships. Can I read, my lord, only 2 paragraphs?
Which is that?
Lord, that, my lord, we have given, my lord. The book, my lord, we have given the citation. Lord, here, when Punjab and Himachal were separated, the number of legislative assemblies were changed, which clearly amounted to amending the Constitution. So there was a clear breach of Articles 170. Clear breach. Lord, that is Mangal Singh and another versus Union of India, 1967 SCR. 1967 2 SCR 109. Lord, can you come to 5, para 5? I'll read Lord, the relevant part of it. Para 5. Lord, there were changes in the legislative assembly numbers in violation of 170, Article 170. Constitution of Legislative Assembly of Haryana. Lord, let me read 4. Section 24 of the Act. It is provided that the total. I'm sorry.
1 second, which AR you reading? You got an AR actually.
Here got AI.
Mangal
AIR,
Singh.
my lord, your lordship's hair.
Mangal Singh.
Mangal Singh versus Union of India.
But paragraph should be
No.
different.
That's a different Mangal Singh.
This is a different Mangal.
Lord, starting is by section 24.
1 second. Name.
No, it's not even a constitution bench.
So this is some CPC. Order 22.
Lord, this is by my Lord Justice J.C. Shah.
No. Bhargav.
That is page 944, brothers. Page 944.
Lord, 944. I'm sorry, we gave 944 only.
We are
AIR.
having AIR.
Yes, sir.
There's a Mangal Singh versus Ratnu Devi.
AIR 1960. It may be our mistake also.
944.
AIR 1967 SC.
The first volume.
There is no
First
इसमें नहीं है.
first.
First volume दे दो.
Appears to be matched. Our mistake.
And because that was just 3 judges, I was wondering how, it's not a CB.
No, my lord, this is a CB. This may be a larger bench because in those days, my lord, maybe there was not necessarily a reference, but maybe a reference also, my lord. It's not coming out. By Chief Justice Subbarao, Justice J.C. Shah, Justice S.M. Sikri, Justice Ramaswamy, V. Ramaswamy, and Justice C.A. Vaidyanathan.
मिला आपको भी भेजो
Read counsel. We'll hear.
No, I would like the lordships to read, my lord, because this would, my lord, touch upon 4, that when it is a state reorganization, all incidental provisions, even if that amounts to amending the constitution, is permissible. It's a, my lord, highest plenary power of the parliament. My lord, kindly come to the my lord, para, whichever is your lordship's para, which starts with
para 6 actually.
by section 24, your lordship said.
No, actually in para 6, the law so made may also, second column, may also make supplemental, incidental and consequential provisions, which would include provisions relating to the setting up of legislative, executive and judicial organs of the state, essential to effective at state administration under the constitution, expenditure and distribution of revenue, apportionment of assets and liabilities, provisions as to services, application and adaptation of laws, transfer of proceedings and other related matters.
On next list.
We just-
Kindly read the next one.
On the plain words of Article 4,
On plain words of Article 4, there is no warrant for the contention advanced by counsel for the appellants that the supplemental, incidental and consequential provisions which by virtue of Article 4 Parliament is competent to make must be
All right.
supplemental, incidental or consequential.
so under the Reorganization Act, they could have made these provisions in it.
And my lord, Parliament possibly knew that it's going to be state again, it's a temporary phase. I can't, my lord, make that statement here, but it's always, my lord, desirable that
Now, Premchand Jain के बारे में उनको कुछ All right.
another Jain, my lord, can address for 5-7 minutes.
All right.
The last point, and for 3 minutes. My learned friend, my lord, rightly said that there is a judgment of Bir Singh, that's a constitution bench judgment. There the question was that a person who is a scheduled caste or scheduled tribe in other states, would it be a scheduled person or scheduled tribe in another state? And that happened from the NCT of Delhi. My lord, the court, I'm not relying upon, my lord, it doesn't touch 239 AA. I'm very honest, my lord, candidly saying, I'm not relying upon for 239 AA. But after examining the administrative hierarchical infrastructure of Delhi, the court said that these are all central services and applied central reservation for GNCTD also.
What is the citation of that BSP?
2018, 2018, volume 10 SCC 312, para 43 to 69.
Volume 1.
Stop at reading 42, last line, which says that we are not touching 239AA. It doesn't, their lordship did not touch. But thereafter, the court examines the entire infrastructure, the rule provisions, and holds that it is a central service. All India Services Act, classification, CC rules, classification and rules, every rules, my lord, are examined, and this is the finding letter. That's all. My lord, if your lordships can give 10 minutes.
Thank you, Mr. Solicitor.
I'm immensely grateful, my lord, for a more than patient hearing.